This development will destroy our community.
Mr. Mercer, I understand your concern, but the board has voted.
My leg is on this land, look!
Look! This is about progress.
They didn't knock. They didn't ask. One day I looked at a map in a county office and realized 96 homes were being built on land that still legally belonged to me. Streets were paved. Foundations were poured. Families had already picked out curtains. And the HOA? They acted like I was the problem, issuing warnings, fines, threats, telling me to stay quiet and let progress happen. So I did. I stayed quiet. I let them finish everything. And then, when the timing was perfect, I walked into a courtroom with one document they never thought I had. The moment I unfolded it, the entire neighborhood went silent. My name is David Mercer. I'm a high school history teacher, which means I spend my days talking about the past and my nights trying to live with it. Before any of this turned into lawyers, surveys, and court filings, life on that land was quiet in a way that felt earned. I had bought the property years earlier, long before anyone thought the area was worth developing. It wasn't glamorous. Just a wide stretch of land on the edge of a growing county, bordered by scrub trees, uneven fencing, and a long gravel access road that most people ignored. To me, it was stability, something tangible. I paid the taxes on it every year, kept the paperwork organized, and treated it like what it was, an asset meant to sit patiently until the right time. Back then, the neighborhood nearby was small. A few dozen homes, mostly families who valued privacy and predictability. No drama, no loud disputes. People waved, kept their lawns trimmed, and stayed out of each other's business. There was an HOA, but it barely registered. It handled basic maintenance, collected modest dues, and sent the occasional newsletter that most residents skimmed and forgot. I wasn't part of that HOA. My land sat just outside their formal boundary, something clearly reflected in the original plats and county records. That distinction mattered to me. It meant autonomy. No committees deciding what I could or couldn't do. No surprise rules. No letters taped to my door for years. Nothing changed. Then the county started growing. What used to be empty space slowly turned into opportunity. Survey trucks appeared. Utility companies marked the ground with bright paint. Developers began attending zoning meetings. The nearby HOA suddenly found itself sitting next to land that was no longer invisible. At first, the changes were subtle. More traffic on the access road, new signage announcing future development. A few HOA emails circulated about protecting community character and planning responsibly for growth. None of it involved me directly, and I didn't insert myself where I wasn't invited. But something shifted in the tone. The HOA board expanded. Committees were formed. Meetings became more frequent. Their language grew more confident, more territorial. They stopped talking like caretakers of a small neighborhood and started talking like stewards of the entire area. Around that time, I began receiving mail that wasn't meant for me. HOA updates, notices about infrastructure improvements, long-term development plans. I assumed it was a clerical error and ignored it. Then I noticed heavy equipment on the edge of my property. At first, it looked temporary. Survey markers, stakes, flags. I double-checked my boundaries against the county maps I had stored away years earlier. Everything still matched. The land was mine. Clean title. No easements I hadn't approved. Construction didn't stop. Roadbeds were laid, curbs appeared, crews worked quickly, confidently, like every permission had already been granted. When I contacted the county, I was bounced between departments. When I reached out to the developer listed on the signage, responses were vague and delayed. And the HOA? They started acting like I was already under their authority. Letters arrived referencing community standards and development coordination. Nothing outright threatening, but the implication was clear. They believed this land was part of their vision now, part of their jurisdiction, part of their future. Still, no one asked me to sign anything. No purchase agreement, no easement request, no compensation discussion. Just momentum. Most people at that stage would have rushed to confront it, filed complaints, made noise, demanded immediate answers. I didn't. Instead, I watched. I read. I pulled old documents from storage and compared them to new filings. I noticed discrepancies others seemed to be glossing over. Quiet ones, technical ones, the kind that don't matter until they matter more than anything else. And as the HOA celebrated progress and the neighborhood expanded toward my land, I realized something unsettling. They weren't being careless. They were being confident. Confident that no one would stop them. Confident that whatever lines once existed no longer mattered. Confident that by the time anyone questioned it, it would be too late to undo. They had no idea how wrong that assumption was. As construction pushed deeper into the land, the situation stopped feeling abstract and started feeling invasive. What had once been survey stakes turned into permanent lines of asphalt. What had been occasional equipment became a daily presence. Trucks arrived at dawn and left after sunset. Entire sections of my property were reshaped without so much as a courtesy notice. Trees were cleared. Soil was compacted. Drainage patterns changed in ways that would take years to undo, and yet, on paper, nothing had changed. Every county record still showed my name. Every tax bill still came to my address. No sale, no transfer, no easement, no condemnation order. The land was legally untouched, while physically transformed. That was when the HOA's tone shifted from confident to aggressive. The first official notice arrived by certified mail. It referenced unauthorized interference with community development and warned that my failure to cooperate with ongoing improvements could result in penalties. The language was deliberately vague, written to sound authoritative without actually citing anything enforceable. I read it twice, then a third time, looking for substance. There was none. Still, the message was clear. They were no longer pretending this was a misunderstanding. They were asserting control. More letters followed. Some warned about safety violations. Others accused me of obstructing progress by creating uncertainty. One even referenced fines for non-compliance, despite the fact that I wasn't, and never had been, part of their association. Each letter assumed something dangerous, that repetition would turn fiction into fact. At the same time, construction accelerated. Foundations went in. Framing began. Utilities were extended. Streets were named. Signage appeared marketing a new phase of the neighborhood, complete with glossy renderings and cheerful slogans about community and growth. 96 homes. That number became impossible to ignore once it was printed on planning documents and promotional materials. 96 families, 96 mortgages, 96 assumptions that the ground beneath them was secure. The HOA began hosting celebratory events, groundbreakings, photo ops, updates praising the board's vision and decisive leadership. The project was framed as inevitable, irreversible. Anyone who questioned it was portrayed as standing in the way of progress. Behind the scenes, pressure mounted. County officials became less responsive. Emails went unanswered. Calls were routed to voicemail. When I did get someone on the line, they spoke cautiously, deflecting responsibility and emphasizing how far along the project already was. That phrase came up again and again. How far along? As if progress itself created permission. Then came the fines. They were small at first, administrative fees, processing costs, charges for delays. None of them were enforceable, but that wasn't the point. The point was intimidation. Paper cuts meant to wear me down. The HOA sent notices warning that unpaid balances could escalate into liens. That phrase wasn't accidental. It was meant to trigger fear, to suggest consequences without actually having the authority to impose them. What they didn't realize was that every letter helped me. Each one established a record, a timeline, proof that they believed they had jurisdiction where none existed, proof that they were acting not out of confusion, but assumption. Meanwhile, construction crews began treating the land like it was unquestionably theirs. Temporary fencing went up, blocking access to areas I had used for years. Equipment was stored overnight. Materials were staged on cleared sections. When I objected, I was ignored. When I documented it, I was dismissed. The message was consistent. This was happening whether I liked it or not. At one point, a representative from the HOA attempted to frame the situation as a technicality, a minor oversight that would be resolved once paperwork caught up with reality. They spoke about cooperation, compromise, and shared benefit, all while the physical reality on the ground became harder to reverse by the day. What they never offered was compensation. No buyout, no lease, no negotiation. They didn't see me as a stakeholder. They saw me as an obstacle. That became clear when the tone of the notices changed again. The language hardened. Deadlines appeared. References to legal remedies were sprinkled in without specifics. The HOA's confidence was no longer subtle. It was overt. They assumed that by the time anyone forced the issue, the presence of homes, roads, and families would outweigh whatever old documents I might have. They were betting on inertia, on the idea that courts wouldn't undo something so far along, that no one would dare disrupt an entire neighborhood over a technical dispute. They were betting that I would blink first. Instead, I stayed silent. Construction continued without resistance. Homes reached completion. Sales closed. Families moved in. Mailboxes were installed. Lawns were laid. 96 houses became occupied spaces filled with routines, schedules, and assumptions of permanence. And through all of it, I kept documenting. Every encroachment, every notice, every filing, every discrepancy between what was being built and what had been approved, between what the HOA claimed and what the records showed. The deeper I looked, the clearer the pattern became. This wasn't a single mistake. It was a chain of shortcuts, boundary lines adjusted without proper authorization, assumptions carried forward because no one challenged them early enough, permits issued based on outdated or incorrect plats, oversight diluted by the sheer pace of development. The HOA relied on momentum to mask precision, and the county relied on the HOA's assurances. By the time the final homes were completed, the situation had reached a point of maximum pressure. The HOA escalated again, this time formally threatening legal action against me for interference and failure to cooperate. The irony was almost impressive. They were preparing to accuse me of disrupting a project built entirely on my land. They had lawyers. They had resources. They had public support from residents who believed the narrative they'd been told. What they didn't have was clean authority. They didn't know that years earlier, when I first acquired the property, I had insisted on something most people overlooked: a detailed survey, a quiet clarification in the chain of title, a record that addressed an ambiguity no one thought would matter. It sat untouched while they celebrated progress, while they issued fines, while they threatened liens, while they assumed silence meant surrender. By the time the HOA filed their action, confident and prepared, the stage was set in a way they never anticipated. Because for the first time since construction began, I wasn't reacting anymore. I was ready to respond. And when I did, it wouldn't be with another letter, another call, or another warning. It would be with something irreversible. The turning point didn't arrive with sirens, shouting, or sudden drama. It arrived quietly, wrapped in procedure, disguised as routine. The HOA believed they were finally in control. Their legal filing was confident, almost celebratory. It accused me of obstructing development, interfering with community interests, and causing financial harm through inaction. The document leaned heavily on one assumption, that the land dispute was already settled by reality on the ground. Roads existed, homes existed, families existed. Therefore, ownership was a formality that no longer mattered. They expected compliance, or settlement, or silence. What they didn't expect was timing. I let their filing stand unanswered just long enough for confidence to harden into arrogance. Long enough for them to publicly frame the case as a nuisance claim brought against a stubborn landowner who had waited too long to object. Long enough for board members to reassure residents that everything was under control. Then I filed my response. It wasn't emotional. It wasn't loud. It didn't accuse or threaten. It simply attached documents. A full chain of title. A certified survey, county acknowledgments, historical plats that predated the HOA itself, and one quiet clarification filed years earlier that resolved a boundary ambiguity the entire development depended on. The land beneath 96 homes had never been transferred. Not partially, not conditionally, not accidentally, never. The effect was immediate, even if it wasn't visible yet. What had been framed as a minor dispute transformed into something far more dangerous. The HOA's case was no longer about enforcement or compliance. It was about authority. About how 96 homes were approved, built, and sold on land the HOA did not own, control, or have legal access to. The court ordered a pause. Construction was already complete, but enforcement actions froze. The HOA's fines stopped. Their threats went silent. Their confidence fractured into urgent meetings and closed-door consultations. Residents began asking questions. Developers stopped returning calls. Title insurers noticed. What followed was a shift you could feel without seeing. A kind of institutional panic. The HOA attempted to reframe the issue as a clerical misunderstanding, something that could be resolved with retroactive easements or compensation. But that strategy depended on cooperation. I didn't offer any. Instead, I requested what I was entitled to, recognition of ownership and remedies consistent with the law. That was when the weight of the situation finally became unavoidable. If the court ruled in my favor, the HOA wasn't just wrong. They were exposed. Their authority evaporated beyond their original boundaries. Their decisions, permits, and representations came under scrutiny. Every homeowner who had been assured of clear title suddenly found themselves standing on uncertainty. The HOA tried to regain control the only way they knew how, by escalating. They painted me as reckless, as vindictive, as someone willing to destabilize an entire community for personal gain. They emphasized families, children, stability. They leaned hard into emotion. What they couldn't lean into was legality. The court proceedings stripped away the performance and left only records, dates, signatures, jurisdiction. And with every filing, the imbalance became clearer. The HOA had acted as if permission was implied. The law did not agree. The climax arrived not in a dramatic verdict, but in a hearing that lasted less than an hour. The judge didn't raise their voice, didn't scold, didn't editorialize. They simply acknowledged the facts as presented and stated what should have been obvious from the beginning. Ownership had never changed. Jurisdiction had been assumed, not granted. And development did not erase title, The room shifted. What had been an aggressive legal posture collapsed into containment. The HOA's attorneys adjusted their tone. Requests replaced demands. The narrative flipped in real time from accusation to mitigation. Because now, the question wasn't whether I had waited too long. The question was how they had moved so fast without securing the one thing that made everything else legal. The court didn't order immediate action against homeowners. It didn't displace families or tear up roads. But it did something far more consequential. It affirmed my rights. Publicly. Officially. On record. The HOA's authority over the land was null. Their fines were void. Their threats were baseless. And any future use of the property would require my consent. That single acknowledgement changed everything. What followed was a scramble. Developers sought negotiations they should have initiated years earlier. Insurers demanded explanations. HOA board members resigned quietly, one by one, as the weight of their decisions became personal. Residents were forced to confront a reality they had never imagined, that stability built on assumption isn't stability at all. And me? I didn't celebrate. I didn't gloat. I watched. Because the real impact of the ruling hadn't landed yet. It was still working its way through paperwork, contracts, and conversations that would take months to unravel. The HOA had lost something more valuable than the case. They had lost credibility. Their power had depended on the belief that resistance was futile, that rules were absolute, and that momentum justified authority. In one moment, that belief cracked. And once it cracked, everything built on it became questionable. As the hearing ended and the record closed, there was a brief pause, a silence heavy enough to feel physical. Not because anyone was surprised, but because everyone finally understood what had happened. They hadn't just overstepped. They had built an entire neighborhood on land they never controlled. And now, for the first time since construction began, the future of those 96 homes wasn't in the hands of the HOA anymore. It was in mine. The aftermath didn't arrive all at once. It unfolded slowly, the way consequences usually do when people mistake momentum for permission. Once the court affirmed my ownership, the HOA's authority over that land didn't just weaken, it disappeared. Every notice they had issued, every fine they had threatened, every assumption they had made evaporated overnight. Their letters stopped. Their emails went quiet. The confident language that once filled community updates was replaced by carefully worded statements about ongoing review and next steps. Behind the scenes, reality was catching up. Developers who had once treated me as an inconvenience now requested meetings. Not to argue, not to pressure, to negotiate. The tone was different, measured, cautious, aware that leverage had shifted permanently. They wanted easements, access agreements, long-term solutions that would allow the neighborhood to function without legal uncertainty hanging over every title. This time, the conversation started where it should have years earlier, with consent. Nothing moved forward without it. For the residents, the impact was unsettling at first. Most had no idea how the situation had been allowed to develop this far. They had trusted the HOA, trusted the paperwork they were told existed, trusted that someone else had verified what needed verifying. Now they were learning that trust, when it isn't backed by diligence, is just assumption wearing a nicer name. Importantly, no one was displaced. That fear had fueled much of the HOA's public narrative, and it never came true. The law didn't demand chaos. It demanded correction. Solutions were found through agreements, compensation, and formal boundary resolutions that should have been handled before the first foundation was poured. But those solutions came at a cost. The HOA's finances took a hit. Legal fees mounted. Insurance premiums spiked. Special assessments were discussed, then quietly implemented. Board members who had championed the expansion suddenly stepped down, citing personal reasons and burnout. In truth, their credibility was gone. Once residents realized how casually authority had been assumed, every past decision came under scrutiny. Budgets, rule enforcement, prior fines. The illusion of competence cracked, and when it did, people started asking questions they should have asked long ago. The HOA shrank back to what it legally was, a neighborhood association, not a governing body over land it didn't own. For the county, the situation triggered internal reviews. Permitting processes were tightened. Reliance on third-party representations was reevaluated. Quiet policy changes followed, the kind institutions make when they don't want a repeat of something embarrassing. No one announced those changes. They tried to build authority out of momentum and silence, but ownership doesn't disappear just because someone ignores it. Thanks for staying with my story. If it made you think, question, or look twice at power and paperwork, that's the point. See you next time.